people's turn now. Mr. Undole, 45 minutes to you.
May it please the court, my lord, my lady, for the record, counsel's name is Ulundole, initial J, and I am appearing on behalf of the Social Democratic Liberal Party, also known as SODALPA. And I will be addressing this honorable court on the following points. One, the validity of the 2013 Constitution. I will argue that the Constitution be declared invalid primarily for the following reasons. A, it was not validly promulgated according to the common principles, and B, in any case, the 2013 Constitution has provisions that are inoperable in practice, and in others which do not agree or do not serve the welfare of the ordinary people and serve democratic principles, but intended to concentrate power on a few selected individuals, officers, and institutions for their benefits and power. Two, I will address the court on the status of the 1997 Constitution. I will be arguing that the 1997 Constitution remained the legitimate Constitution. Three, if the 2013 Constitution is invalid, I will address actions which should legalize all actions taken by respective governments under the 2013 Constitution. The 1997 Constitution comes into operation. And four, finally, I would address the court with interim measures which should be taken to bring into force the 1997 Constitution. If I have time, my lord, my lady, I will conclude with a story. That's if I have time, my lord. I will now address the court in some details on each of the following 4 points. I will first deal with the first 2 points simultaneously or together. That is the validity of the 2013 Constitution and the status of the 1997 Constitution. My client's submission is that a Constitution is the fundamental law upon which all other laws of a country are based and must conform. The Constitution is the written, sometimes unwritten, basic definition of the character of a country and the structure of the government in that country. It is one of the cornerstones of democracy. While the drafting of a country's constitution is not typically governed by case law in the same way as ordinary legal matters, constitutional convention, these are the unwritten rules of practice, my lord, can play an important role in drafting a constitution. However, any guidance from the court on constitution building process in democracy would be helpful in view of the fact that Fiji has had 4 constitutions in its short history, and Fiji's constitutional building process has been wanting. So SODALPA's submission is that democracy, by its very nature, demands practically a participatory constitution building. Participatory constitution building, especially during times of transition from authoritarian to democratic rule, has become an established norm. Constitution should be based on consensus. The document should reflect a set of principles that citizens in a country can agree upon to enable a consensus adoption by their representatives. A constitution should be above partisan politics and should define the terms of government and interactions which any party or political group will respect. As I mentioned earlier, in Fiji's short history, unfortunately, we have had 4 constitutions. I believe the Honorable Court has been provided with the history of the drafting and adoptions of the 4 constitutions. Briefly, the 1970 Constitution was adopted following Fiji's independence from the British. It was enacted through an order in council issued by the British monarch. The Constitution was the result of a negotiation between leaders and the British. The 1970 Constitution was a result of the negotiation and compromises between various political parties in Fiji, aimed at balancing the interests of ethnic groups in Fiji. The 1990 Constitution, however, was established through a Fiji's Constitutional Inquiry and Advisory Committee to draft a constitution. The committee conducted public hearings, submitted draft to the Great Council of Chiefs, GCC, in March 1989 and again in 1990. The Methodist Church and the Great Council of Chiefs endorsed the Constitution. The Constitution was adopted through a presidential decree in July 1990. This was a particularly difficult time in Fijian politics, my lord, and the adoption of the Constitution faced controversy. It was subject to intense criticism and was not being democratic, and it was not a democratic constitution. However, the significant redeeming feature of the 1990 Constitution was Clause 161, which stipulated this Constitution shall be reviewed after a period of time, but before 7 years, after the promulgation of this Constitution. Therefore, the Constitution shall be reviewed. Thereafter, the Constitution shall be reviewed every 10 years. My lords, Clause 161 allowed for review of the 1990 Constitution. In 1995, the then Prime Minister announced the establishment of a Constitutional Review Commission, led by New Zealander Sir Paul Reeves. His commission conducted extensive public consultation and received a significant number of submissions from NGOs, provincial council groups, and others before submitting it to the government for consideration by the Joint Parliamentary Sector Committee, JPSC, which adopted the majority of the recommendations submitted by the Commission. One of the provisions introduced by the JPSC was the power sharing in government. Hence, the 1990 Constitution was modified and a new Constitution was adopted unanimously by the 2 Houses of Parliament and endorsed by the GCC. It was such a consensus Constitution. In contrast, my lord, the 2013 Constitution was not a consensus document. The document does not reflect a set of principles that all citizens in a country can agree upon, and most recently, when a motion was introduced by government to amend certain provisions of the Constitution, branded as inoperable. I have earlier stated, my lord, that a constitution in a democracy should be above partisan politics. The 2013 Constitution commences with the words, we, the people of Fiji. But it was not assembled by any expert committee selected transparently, or through a people's assembly, or through an elected authority, or passed in a referendum. The Constitution centralizes power in the hands of the Prime Minister and his Attorney General, and grants the military extraordinary powers and immunities. Nevertheless, it is one of the highest thresholds for amendment in the world. It cannot be changed except by a double 75% majority. First, backing of 75% of parliamentarians, followed by the 75% of registered voters in a referendum, an insensibly high threshold. My Lord, we agree with the Solicitor General that the double supermajority requirement, which necessitates both three-quarters majority voted in Parliament and subsequently approval by three-quarters of registered voters in a referendum, presents significant challenges in practical terms. Given that achieving such a high voter turnout is particularly difficult when voting is not compulsory in Fiji. These requirements effectively limits the possibility of a constitutional amendment being successfully enacted. While these provisions aim to safeguard the Constitution, it raises concern about whether it severely restricts the ability to adapt the Constitution through a democratic process. So the submission is those advocating the validity of the 2013 Constitution should be obliged to establish that the democratic norms of constitution building was followed. We submit that the 2013 Constitution was unilaterally imposed on the people of Fiji in the background of a government supported by a military, and not in the background of participatory democracy. Furthermore, the 2013 Constitution was adopted in defiance of Fiji's law. The Fijian Court of Appeal held on the 9th of April that the actions of Commodore Bainimarama in seizing the executive authority in December 2006, dismissing the Prime Minister Laisani Angarase, and dissolving Parliament were invalid, as was Bainimarama's appointment as interim Prime Minister. However, there has been no determination by our court to date on the legal effect of the promulgation of the 2013 Constitution. The court is best positioned to resolve this issue definitively. This includes determination of our action taken under the 2013 Constitution can be reconciled. This is where we submit the court has room to move. It has the original jurisdiction under Section 98(3)(c) to hear and determine constitutional questions referred to it. The current Supreme Court reference raises the question of whether the court can interpret the status of 1997 Constitution without violating Section 173(4) of the 2013 Constitution. The clause restricts the court from revising the legality of the events that led in the 1913 Constitution, including the abrogation of the 1997 Constitution. We agree with the Solicitor General and other experts that the court can interpret the legal status of the 1997 Constitution without violating this provision. Critics agree that such a clause undermines the principle of constitutional supremacy and rule of law, as it prevents the judiciary from holding the executive accountable for unconstitutional actions. In constitutional law, my Lord, outer clauses like 173(4) are often controversial. Courts in other jurisdictions like India, South Africa, and the United Kingdom have sometimes read such clauses narrowly to preserve judicial oversight, especially where fundamental rights or constitutional structure are at stake. In the case of Anismic Limited against Foreign Compensation Commission, the House of Lords held that a statutory clause stating that the decision shall not be called into question in any court of law did not prevent the judicial review of the decision maker and acted outside the legal power. This case established that errors of law could render a decision void and thus not protected by an outer clause. It might be argued by supporting the 2013 Constitution that the abrogation of the 1997 Constitution was done after the Ngarase case, and the ruling in the subsequent abrogation that the Ngarase case did not address the abrogation of the 1997 Constitution. Our submission, my Lord, is that both the Chandrika Prasad case and the 2009 Ngarase case upheld the supremacy or the constitutional or the Constitution's supremacy. And also, two, the act of the 2009 abrogation was made while the 1997 Constitution was active. Any interference with the 1997 Constitution had to be done in accordance with the provision in the Constitution. In fact, the People's Charter, initiated by the interim Bainimarama government on 15 December 2008, begin its provision as follows. We, the people of Fiji, affirm that our 1997 Constitution represents the supreme law of our country and provides the framework for the conduct of government and the people. Our humble submission, my Lord, is that the 2009 abrogation was a rogue act of then interim government. It was done contrary to the Constitution. It was an invalid and illegal act, and we pray that the Supreme Court should determine it as such. Now, my Lord, I wish to turn to my further points. 3 and 4, namely, 3, the 2013 Constitution is invalid. What will happen to the actions taken by the respective government under the 2013 Constitution? And 4, what interim measures should be taken to bring into force the 1997 Constitution? We note that the Honorable Chief Justice had asked in the preliminary hearing of the referral on 6 June 2025 to the effect as to how can this court rule that the 2013 Constitution is invalid from day one, when several parliaments have been elected under the Constitution, myriads of legislation has been enacted under the 2013 Constitution, and the government of the day have made hundreds of appointments under the 2013 Constitution, myriads of essential administrative and governance decisions under the authority of the 2013 Constitution since 2006, including the establishment of this very court. The practicality of recognizing acts done under the 2013 Constitution is of utmost pertinence, and such actions are referred to in the Judicial Committee of the Privy Council in its 1979 decision in Matsimambuto, as required for the honorary running of the state. The case is acknowledged by the Fiji Court of Appeal in the Prasad case. In passing, the Privy Council commented on the acts of illegal regimes, ruling that the action of the interim regime could be recognized as valid insofar as they are required for the orderly running of the state, but do not impair the right of the citizens and do not aid in the usurpation of the constitutional order. Our submission, my Lord, is that this honorable court can rule that the 1913 Constitution is invalid and the 1997 Constitution has not been abrogated and remains the law. In order to avoid chaos in government, for the honorary running of the state and for practical reasons, on the basis of necessity, the court can rule that the government actions taken under the 2013 Constitution since 2006 until 2013 must remain valid to avoid chaos. Our court can determine that the 1997 Constitution is legally valid Constitution of Fiji, and in order to bring it into force, a general election to be called under the 1997 Constitution to implement the court's determination. However, it is not practical or possible to call on the deposed parliament, sworn under the 1997 Constitution in 2006, to be called to session. In order to call a general election under the 1997 Constitution, we understand a lot of work will be necessary, which cannot be done overnight. It can be determined that an interim government needs to be formed. In order for the least disruptions, the present government can be designated as the interim government operating under the 2013 Constitution and until the completion of its term under the 2013 Constitution. My Lord, my Lady, on behalf of the Suva, if there is no need for a longer interim period than the present term of government. All work for the preparation of general election can be done effectively until the end of the term of the present government.
Under what system of representation? Under the current one or under the one provided for in the 1997 Constitution?
Assuming that we continue under the 2013 Constitution, but at the same time we prepare for the election for the 1997 Constitution, my Lord.
So would this election be next year?
Yes, I think the cutoff date is 27th of January, 2028.
No, 27.
27.
Okay. And it would be elected on the current proportional representation provided for in the. Well, there wouldn't be a Senate.
What we're suggesting, my Lord, is if the court declares that the 2013 is invalid, but recognizes the act and the fixed principle in Matsimambuto, we can continue with the 2013 Constitution. But the election has to be in the 1997, which we believe, or we submit, we just diminish the 2013 Constitution.
Go back to your earlier submission, which you, and I'm here referring to the words you used, suggested that one of the 2013 could be void, null, ab initio. We use firm on that?
Pardon, my Lord?
You said the 2013 Constitution may be void, ab initio.
in our original submission, we have stated in our original submission that we cannot abrogate the 2013 Constitution ab initio, meaning from the beginning, because then it would bring chaos. And that's why we have suggested the principle laid down by the House of Lords in Machimabuto to recognize all those acts.
You're asking this court, this particular court, to do something that is not covered by Section 5A, B, C, D, E.
That's correct, my lord. We are submitting that the court has the power, the jurisdiction to do that.
We were searching for that power for the last 2 weeks.
Well, the court has inherent, as I've stated before, earlier in my submission, it has original jurisdiction.
Thank you, Mr. Ronaldo.
May I continue, sir?
Yes, indeed.
Our submission is that this honorable court can rule that the 2013 Constitution is valid and the 1997 Constitution has not been abrogated and remains the law in order to avoid chaos in government, for the only running of the state and for practical reasons on the basis of necessity. The court can rule that the government actions taken under the 2013 Constitution since 2006 till 2013 must remain valid to avoid chaos. The court can determine that the 1997 Constitution is the legally valid Constitution in Fiji in order to bring into force a general elections which need to be called under the 1997 Constitution. In order to call a general election, my lord, under the 1997 Constitution, as I stated before, we understand it's not easy. So my lord and my brief on the survey is that there is no need, as I've stated before, for a longer period. The present term of government should suffice. Using the words of the Privy Council in Machimabuto, the acts of legal regimes since 2006 is recognized as valid insofar as they are required for the orderly running of the state, but do not impair the rights of citizens and do not aid the usurpation of the constitutional order. To conclude, my lord, a story of a little girl who had a little bird in her hands. He saw a man of God walking towards her. He wanted to test this man of God. So he went to the man of God and asked the man of God, is the bird alive or dead? The man of God thought, if I say that the bird is alive, she could squish the bird and it will die. And if I say it's dead, then he would open his arms and the bird will go free. My lord, the future forward for Fiji is in our hands. And so therefore, I assured, rest assured that we are in capable hands. Thank you, my lord.
Thank you, Mr. Ulundole.
Sorry, my lord. Sorry.
Any questions? None?
Could I just ask a question about the criteria, the factors that are set out in the Prasad decision about how the court goes about recognising the legitimacy or otherwise of a revolutionary government. And one of the factors mentioned is elections, success at elections. Now, as I understand it, from the multinational observer reports and from the platforms of the parties and so on. Certainly the 2014 election and the 2018 election were fought very much on the basis of these two constitutions. So SODELPA's platform was we should move away from the 2013 constitution and back to the 1997. The government, the Bainimarama government, was saying, no, we should stick with the 2013. Now, given that there have been elections where that issue of those two competing constitutions and the very different visions of Fiji that each one presents, since that was put to the electorate, and in those first two elections, the Bainimarama government won, do you see those elections as having any relevance to the issues before the court or not?
Well, my lord, for the 2014 election, actually SODELPA was going to boycott that election, but it was convinced otherwise to participate and then try and change the constitution inside. So in other words, SODELPA has been participating in the last election by force. We have no choice. We are hoping that one day, while inside there, we'll be able to change it. But until today, we're still waiting.
Right. Well, it might be argued that the people, while not agreeing perhaps with every provision in the 2013 Constitution, have expressed a preference for it. That's the point, arguably. Thank you.
Thank you, Madam.
Right. We will move on to the next intervener, and that is Honourable Sir Ratu's faction in Parliament. Yes, Mr. Singh.
My lords and my lady, I anticipated that I would be given the graveyard shift, so I had reduced my oral submissions into writing for ease of reference, and a copy has also been given to each party. If I can pass this over. My lords, I would not touch on the issue of the previous coups or the previous constitution as to how they came to be. These are matters of...
Has this been served to
Yes, it has been. I would not be touching those because these are all matters of public interest and court can take judicial notice of it. The fourth interveners have a very different view from the rest of the council that's already submitted. We join our hands with the amicus and their opinion into the matter, more particularly in the issue of jurisdiction. Whether this court has jurisdiction to entertain the reference questions that has been posed to you. And if I can more particularly refer the court to section 91.5, which gives the cabinet powers to refer questions, and it states that cabinet may seek an opinion from the Supreme Court on any matter concerning the interpretation or the application of the Constitution. There are two folds to this. It's your opinion on an interpretation of a particular section and how your interpretation can be applied at large. These questions do not ask those. These questions do not ask your interpretation.
Well, let us look first at the first four questions. Do they not raise the question whether the amendment provisions apply?
The first question is in two folds. if I can refer to them, are the provisions of Chapter 11 and of Part D of Chapter 12 of the Constitution of the Republic of Fiji binding on the people of Fiji? That particular question, if it was stopped there, yes, it would. The simple answer to that is yes.
Well, but say the court says it doesn't recognise that as part of a new legal order that conforms acceptably to the rule of law and democratic values.
Yes.
So isn't that a question of application? I mean, if the court disapplies that procedure, then that is a question of application.
The application first would be to interpret a particular section. If the
I'm
court
sorry,
finds-
I missed that.
Yeah. So the first step would be to interpret a particular section. If the court goes and says, yes, this applies, and how it applies, that's the question that this court should answer. And
But why
provide-
can't it say it doesn't apply at all? Isn't that a question of application?
It is not, my lord. It does apply because it's the Constitution. It's
No,
it's-
we are going round in circles on
Yes.
this thing.
It's a recognized law. It was passed. It was accepted. And why I say is this: the Constitution was introduced by a bill. It was the Decree 24 of 2013.
Mr. Singh, don't worry about that
Yes.
decree. If you look back at this reference material you referred to,
Yes,
those two words are in the alternative.
yes,
Okay, so don't try and read them together,
yes,
which is what you're trying to do now. It's either an interpretation or an application.
yes.
And it doesn't, listen to this,
Yes.
it doesn't necessarily read to mean that the application necessarily means the interpretation. Because they are in the alternative, aren't they?
Indeed, my lord. It says it uses the word "or" in it. Yes. So, in sense,
So
that-
you're saying that we shouldn't address whether the Constitution is amendable otherwise than in accordance with its terms,
the Constitution is amendable, my lord,
but otherwise than in accordance with its terms.
with the terms of yes, the sections that has been referred to is in Section 160.
But even though there are obviously serious issues to be addressed as to whether they should be recognised by the court, we can't really just duck it, can we, and say the question wasn't well expressed, or we're stuck in some sort of paradoxical universe where we can't go outside the limits of the jurisdiction conferred by the 2013 Constitution. I mean, that's not going to be much good for Fiji.
Yes, and I agree with you, my lord. So, in interpretation, yes,
I don't think you are agreeing with me, actually.
the intervener's opinion to the question is that yes, the law is applicable, and there is no way to suggest otherwise. If it was not, then that was a question that should have been raised or filed a separate application, as the court, as your Lordship Matetonga had previously asked one of the counsels, is is there any other way that these questions could be asked or answered? And that is yes, there should have been a case filed in the High Court on the legitimacy of the 2013 Constitution, and that's, I believe, has been the crux of everyone's submission in this matter. Now, if I can refer to point 4 of the submissions, my lord, the central to both submissions that the parties that we have submitted, section 159 and 60, are procedural and substantively and self-entrenched. We agree that yes, it is self-entrenched. Section 1592 explicitly prohibits any amendment that would repeal, infringe, or diminish Chapter 11, Chapter 10, or Part D of Chapter 12. These clauses are absolute, meaning that neither the Parliament nor referendum can amend these provisions.
Even though they are procedural in nature.
Yes. So, I'm sorry, couldn't get your question, my lord.
Even though both 1592 and 160
Yes.
are manner and form provisions. Do you agree?
Is a matter of reform.
Manner and form provisions.
I would agree.
Yes or no? It can be anything else.
Yes, I would agree.
In which case, if it is purely that, therefore it's a procedural issue. Don't try and make it a doctrinal issue when it isn't.
Yes.
Carry on.
The strict dual threshold of 3/4 of the Parliament plus 3/4 of the registered voters in a referendum reflects is a deliberate design, would agree to protect the Fiji's constitutional order from opportunistic and destabilizing changes. Comparative jurisprudence supports this is in Germany, the eternity clause. The South Africa's, in the case of fundamental entrenchment, all highlight the legitimacy of unamendable constitutional norms. So there are provisions in other jurisdictions where some part of the constitutions are unamendable. And some of these goes towards the Bill of Rights itself. The popular sovereignty versus the parliamentary supremacy, the state has argued that the entrenchment undermines the popular sovereignty or parliamentary authority. The fourth intervener responds that this sovereignty in a constitutional democracy is structured by the Constitution itself, not by majoritarian will. Section 2 of the 2013 Constitution affirms that the supreme law binding on all state institutions and individuals. Thus, the Parliament cannot assume this supremacy over the Constitution, nor can public opinion alone override the entrenched protection. This interpretation aligns with the South Africa's Makawane case, where the Constitutional Court held that the public opinion cannot replace the constitutional adjudication. Some have argued the issue of necessity to bring back the 1997 Constitution. However, necessity in the Chandrika case has stated that it only permits temporary, proportionate measures during genuine emergency. There's no emergency over here. Referendum requirements?
So what do you say about Prasad?
Yes.
I mean, if you look through the criteria in Prasad, this is a pretty obvious case for saying that the 2013 Constitution is valid.
In the Prasad case, I believe they raised a doctrine, if I'm correct. It's the Kelesian theory, which states that in a new regime, a constitution is recognized when it is obeyed by the people, or it is controlled
Well, okay, I'm going to put it to you another way. We're 13 years down, nearly 13 years down the track from the Constitution, 12, I suppose. There have been 3 elections.
Yes.
Has there ever been a case, the usurping government or its alter ego has now lost power? Has there ever been a case where recognition of a new constitution has been withheld when it's been in place for so long and been the subject of, and there have been so many elections conducted under the framework it created? Can you think of a single case where a constitution has been discarded of that character?
I have not
I'd be surprised if you can.
I have not come across any, but this is what the argument of the fourth interveners are. The court is correct. There's been 3 elections held under the Constitution. The public at large has accepted the Constitution. The first election, I believe, had more than 80% of the voter turnout. Now, just because some of the parties think in a referendum 75% would not be achievable, this is wrong. You've not tried it yet.
You are slipping away from the point we're discussing.
Yes, I would agree, but when we were coming to the election part, that's where I got swayed, my lord. I do apologize. So the doctrine of, I believe, there's no necessity for an
But Prasad doesn't turn on necessity.
Yes.
Prasad turns on long practice, acquiescence,
Yes.
elections, acceptance. It doesn't turn on necessity.
Yes. I believe the Beni Marama and Garasi case did.
But that didn't involve a question whether
Yes.
a new constitution
It's
should be
been-
recognised. It turned on whether necessity justified actions that deviated from the text of the acknowledged constitution, which was the 1997 one. So it doesn't really help us much here, does
Yeah.
it?
I would agree, my lord. The referendum requirement under section 163 is vital to democratic legitimacy. It ensures that the amendments reflects not only parliamentary but the will direct to approval of the people. Arguments that voter thresholds are impractical ignore Fiji's historically high voter turnouts and alternative solutions such as compulsory voting. If I can answer one of the questions I believe Justice Arnold asked, is that there's nothing in the in the Electoral Act in relation to how referendums are to be conducted. And yes, this is one of the questions or the opinion this court can give as to how referendums are to be held. It's not necessary for a referendum to be held by way of an election, or you have a particular a base where people come and vote. You can go door to door, house to house, when you're having census taken. So it's not necessary to call for votings. You can go to house and house, check who's registered for vote, and get their votes there and then, either electronically or manually.
How did you, where did the 2013 base their referendum on?
The 2013, when the Constitution was placed, there was no referendums, no. None whatsoever, my lord.
Yeah, the reason I said that because you might have heard earlier that when Guy's report came, it was without a referendum, and then all of a sudden, overnight it became a referendum.
Yes, indeed.
It was 2/3, and overnight it became
3/4. Yes.
some magical things are happening.
Yes. Then we would have to diverge into the makers of the
No.
at
This
that
goes
time.
to the issue of democracy you raised earlier.
Yes.
Don't try and sidetrack it. It goes to the issue of democracy. And it's a serious issue. And it's also an issue that goes to turns on the issue of legality in the way you're arguing it.
Yes.
So if you're going to make a submission, make sure you can back it up in terms of what actually happened.
No, I agree, my lord. In 2013, there was no referendums held. I
Yeah, but
believe
we've never had the history
yes.
of referendum.
Yes, indeed.
Right from 1970, we never had it.
Yes.
And it's not because we didn't consider it. It was considered. But people who know better than us said it's not for us, including the Askai Commission.
Well, my lord, I cannot answer as to why they required a referendum,
No.
but it is so that it is detailed in our constitution that a referendum is needed. And to answer the questions, the 5 questions, my lord. Yes, the first question, they are self-entrenched, binding on the parliament and the people in the courts. And we believe that this is so to preserve the constitutional supremacy. Can an amended bill be passed? Can a bill be put to parliament? We're saying no. Even if passed, such a bill would be unconstitutional. Referendum approval, yes, the Constitution requires the referendum approval. As to how that is conducted is to be seen. And to answer the question, is the 1997 Constitution still valid? We are saying no, it is not valid. Why? Because 3 elections has been held. It has been accepted. And further, one of our arguments is, and we did not touch this in our submissions, and we did so in our oral submissions, is that the caretaker government or the interim government introduced the Constitution of Republic of Fiji Promulgation Decree 2013. That was Decree number 24 of 13. This decree introduced now Constitution, which came into effect on 7th September 2013. On 12th July 2016, Act number 31 of 2016 was passed, whereby under section 107B, 1 and 2, all decrees and promulgation became acts. This was passed in the parliament, recognizing the Constitution of Republic of Fiji Promulgation Act, which entailed the Constitution in it. That is our brief oral submissions, my lord.
Any questions?
No.
Thank you, Mr. Singh.
Thank you, my lord.
So we'll proceed to Honorable Naivalerua's faction, Mr. Vagalalambore.
May it please the court, your lordships and your ladyship, while I address these submissions to you, the G11 is mindful that many Fijians are listening citizens who wish to understand the law that governs their country. I will begin with the short answers to the 5 questions in the reference and to the 2 questions the court have asked us to address in our oral submissions. And then I will turn to the fuller submissions that explain and support those answers. Our answers to Cabinet reference on question 1 to 4 concerning section 159 and 160 of the 2013 Constitution. We say these are entrenched provisions. They must be given their full force and effect, read purposively with section 3, subsection 1 of the Constitution. They require the double supermajority expressly set out in the text and cannot be amended by ordinary majorities. These safeguards protect the basic structure of the 2013 Constitution. On question 5, whether the 1997 Constitution remains valid, the G11 says yes. The 1997 remains the de jure Constitution of Fiji. It has never been lawfully repealed by the processes outlined in the 1997 Constitution. The 2013 Constitution, however, operates de facto, but not in law. By the test in the Chandrika Prasad case that was adopted from Mitchell, Matsimabuto, and Mukotso, the 2013 Constitution fails every limb. Number 1, no lawful origin. Number 2, no constituent assembly. Number 3, no referendum or ratification. And number 4, no proof of voluntary acceptance by the people of Fiji, and it is undemocratic in origin.
Just
In
pause-
short,
pause there. Of the 4 points you've made, 3 don't come out of Prasad at all, do they? The first 3, by recollection, is, and it may be wrong, but that they've come. You've derived them from something else.
they are the test of efficacy, sir.
They are the what?
The test, the litmus test for efficacy.
Yeah, but they're not from Prasad. I mean, Prasad accepts
yes,
that an illegitimately imposed constitution can become a lawful and valid constitution.
Yes, my lord, that efficacy has to be determined by the court that hears it, and we are here. In short, the lawful constitution of Fiji, the one made by the people of Fiji and ratified by their parliament, has never been lawfully taken away. As the Honorable Prime Minister, and I invite the court to take judicial notice, that this is the same Prime Minister who has referred these questions to this Honorable Court. Mr. Intervenor said when introducing the 1997 Constitution Bill in Parliament, recorded in Hansard on the 23rd of June, 1997, and cited in Chandrika Prasad, and I quote, "What will give legitimacy to our Constitution is the principle that it has been developed with the free and full participation of everyone. It provides for a system of parliamentary government based on the consent of the people," unquote. That, your lordships and your ladyship, is the benchmark Fiji has set for itself. By that standard, a constitution, by the observation of this honorable court, drafted by a handful of officials without the people of Fiji's informed participation or consent cannot claim lawful legitimacy today and, in our view, 50 years from now. After these answers, Your Lordships and Your Ladyship, these answers are not from two different lines of reasoning. The same standard governing all 5 questions. In the Republic of Fiji, constitutional change, whether by amending one provision or replacing the entire constitution, can only occur in the manner the constitution itself prescribes. That is not a technicality. It is the safeguard of the people's sovereignty. Your Lordships and Your Ladyships, I will move on now to answer the 2 questions, or address the 2 questions that the court had referred. And I quote for the benefit of the listening public, question number 1. In determining whether it has jurisdiction under the 2013 Constitution, can the court determine whether that Constitution is legally effective by applying the recognition criteria from common law in Fiji, unquote. The G11 says, firstly, the court plain, we have divided it into 3 parts. First is in relation to jurisdiction, we say that under 95.1 and section 98.3 of the 2013 Constitution, this court can answer because cabinet may refer any matter in, and the court is obliged to answer. We've noted that this honorable court had taken into consideration and adopted interpretations that were noted in Garase and Chaudhry case in its formulation of interpreting its most recent opinion. It also noted that in the Supreme Court also affirmed the constitutional interpretation must be approached contextually, purposively, and in light of the values underpinning the democratic society. These questions about legality, Your Lordship, is not a new issue to Fiji's constitutional jurisprudence. We invite the court to look at Chandrika Prasad, where the court says we have no hesitation in holding that courts, including those created by a written constitution, are authorized and required to decide when and if a revolutionary regime has become lawful. They also cited the observations in Madzimabuto that was delivered by Lord Wilberforce, where it says, and I quote, "It is the function of this court to pronounce upon the legality of the acts of the executive when called upon to do so, and especially when the legality of the regime itself is the issue," unquote. We invite this honorable court to also adopt that interpretation and find that not only the text of the Constitution gives you jurisdiction because other matters is very broad and unqualified, and also adopt the principles that I have highlighted. Your Lordships, secondly, in relation to the phrase legally effective, in question 1, we say it is not a doctrine recognized in Fiji's constitutional jurisprudence. Our law, from Chandrika Prasad through to Laiseni Angarase, decisions of the Court of Appeal recognizes only 2 statuses: de jure, lawful in origin, and valid in law, and de facto, operating in fact but without lawful origin. Third, the recognition criteria this court may apply are those already settled in the common law of Fiji, drawn from Matsimabuto, Mitchell, and Mokotso. Proof of lawful origin and the voluntary consent of the people of Fiji, as announced by the then Prime Minister and now Prime Minister in Parliament in introducing the bill for the 1997 Constitution. It has to be proven to a high civil standard to require to confer de jure status. Where that proof is absent, a constitution may operate in fact, but it remains de facto. To include a third doctrine of legal effectiveness in this reference, in our humble view, would be to invent an unknown category into Fiji's law.
You agree that...
And, sorry, sir.
You agree that we have no jurisdiction under the 2013 election to entertain this reference, under the 2013 Constitution, to entertain this reference unless that Constitution has legal effect?
Sorry, my lord.
Yeah. We are asked to exercise a jurisdiction to answer questions under the provisions of the 2013 Constitution. If that Constitution has no legal effect, then we have no jurisdiction to answer those questions, do we?
Sorry, my lord. I didn't hear you well. I'm a little bit deaf, my lord.
Okay. I'll try and speak a little bit louder. The court has been asked to answer 5 questions. 4 of them are relating to the interpretation or application of the amendment provisions. So the court is being asked to exercise a jurisdiction which is said to be conferred on it by the 2013 Constitution. The first task of the court must be, mustn't it, to decide whether it has any jurisdiction. And doesn't that depend upon whether the 2013 Constitution is legally effective?
My lord, in both Chandrika Prasad and Garase, the Constitution has already been abrogated by decrees, and the court made finding to those effect that they had jurisdiction, as I've just stated. And we are inviting the court to view this reference in that light.
So we disregard all the events that have happened since then, the passage of the years, the elections?
Yes, Fiji is a republic where the sovereignty of the people is paramount. And our constitutional jurisprudence says that what we are seeing, sir, is that there are explanations that there has been a successful revolution. A successful revolution in relation to our laws, sir, cannot be successful without the people. There has not been any evidence before the court that the people of Fiji accept the 2013 Constitution. In fact, the Honorable Court could take judicial notice of the platforms in which the current government went into elections, beginning from 2014 to the 2018 to the 2022 elections. And that is, they were all against the 2013 Constitution.
But that doesn't mean they didn't accept it was valid in the meantime. Didn't they go into it on the basis they'd try to change it?
Well, sir, we've got evidence of elections, but this, under a de facto doctrine, goes only to compliance. It does not go to a freely informed consent to accept the 2013 Constitution. This is our position, sir. according to our understanding of our common law.
Your common law, Mr. Awelalamure, in terms of, is actually premised on the 3 decisions that were made before Prasad, Privy Council cases,
Yes, my lord.
which in common law recognizes that in times there are certain situations it will be possible for the court to apply common law principles of recognition. We are not talking about diplomatic recognition here, we're talking about legal recognition, where there is a lacuna in the process of interpreting or application of laws. You agree with that?
Yes, yes, ma'am.
I think that's all that question is asking. I think we're getting trapped in the use of these interesting cases by names, but in fact, you use the Fijian common law. The things it's implicit in this question is actually Fijian common law as well.
Yes, sir. It is Fijian common law. That is what the court said in Chandrika. In the context of Fiji's common law, these are what will amount to a successful revolution. And the linchpin, your lordships and your ladyship, is the free and informed consent of the people of Fiji. I'll move on now to question 2 that the court had directed that we address, and I quote, can the court recognize the 2013 Constitution as legally effective, qualifying its recognition of the amendment provision so as to read them down, unquote. The G11 say no, not as a matter of de jure recognition. To do so would be to confer lawful origin on a constitution that, by the standards of the Chandrika Prasad case and the Laisenia Garcia case, does not meet the threshold. The court may, as in the Laisenia Garcia case, acknowledge the 2013 Constitution's a de facto operation for pragmatic reasons. To preserve continuity of governance, your lordships and your ladyships may express an opinion on how its provisions should be read in practice, but that should not amount to recognize it as legally valid. In other words, your lordships and your ladyship may preserve the machinery of government temporarily, but the lawful source, in our humble view, is the constitutional authority in Fiji remains the 1997 Constitution, until changed by the people of Fiji through the procedures in the 1997 Constitution itself. I will now turn to the pillars of our fuller submissions. Your lordships and your ladyship, the first and most important issue is the foundation of constitutional change. In Fiji, the constitution is the people's constitution. It can only be changed by the people of Fiji through the methods the constitution itself provides. If a government can replace the constitution by decree, then the constitution is no safeguard. It becomes a tool for those in power. That is the very antithesis of republican constitutionalism. In the Chandrika Prasad case, after reviewing the leading common law authorities, the court expressly rejected the success begets law approach. It held the burden of proof I quote, the burden of proof of efficacy lies on the de facto government seeking to establish that it is firmly in control of the country, with the agreement, tacit or expressed, of the population as a whole, unquote. That
Just pause there. How do you say that agreement has to be manifested? What, by a referendum or something?
in the process that was established in the creation of the 1997 Constitution, my Lord, through the Reefs Review. And nationally, there was a national consultation right across the board. Ratification
Yes,
is
yes, but
possible.
that's talking about a constitution that's being established in a genuinely democratic way. Recognition can be extended to a constitution that has been undemocratically established. Would you
That
say-
is possible, my Lord, but in our common law, they have established that lawful origin and participation of the people of Fiji cannot be dispensed with for it to be lawful. That is why we are saying that the 97 Constitution is the de jure Constitution of Fiji, and the 2013 is the de facto. Moving on, sir, that was a deliberate judicial choice by our courts to place legality before mere control. It is now part of Fiji's settled jurisprudence, constitutional jurisprudence. In the Laisiniangarase case, the court reaffirmed, and I quote, "The Constitution cannot be abrogated unilaterally, and military or executive necessity cannot override legality," unquote. Necessity may be a temporary bridge back to constitutional order. It is never a foundation for replacing it. In Fiji, your lordships and your ladyship, those in power must follow the Constitution. The Constitution is not there to follow them. Your lordships and your ladyships, this choice of principle reflects Fiji's republican identity, a nation state where sovereignty rests with the people and where constitutional legitimacy requires their informed and lawful participation. That is the foundation on which every other argument about question 5 must rest. Having set out the principle, the next question is whether this court has the authority and the duty to decide question 5. We say yes, this court not only has jurisdiction, but it has the constitutional responsibility to answer the question lawfully referred to it by Cabinet. Section 91(5) of the Constitution states, and I quote, "Cabinet may refer to the Supreme Court for its opinion any matter concerning the interpretation or application of this Constitution." The words "any matter" are unqualified in that provision. Whether the 97 Constitution remains valid is the most fundamental matter, in our view, imaginable. Section 98(3) adds, and I quote, "The Supreme Court has original jurisdiction to hear and determine any question referred to it under Section 91(5), unquote. As we have confirmed in our submissions consistently that the jurisdiction is clear, Cabinet may refer, this court may determine. The foundational governing constitutional order in Fiji needs clarity. And it is for this honorable court, the duties on this honorable court to provide an opinion on question 5 because it has squarely been referred lawfully by Cabinet. Moving on, your lordships and your ladyship, some have pointed to Section 1734, the transitional ouster clauses, saying it ousts the jurisdiction of the court with respect to question 5. Respectfully, that provision cannot be read to abolish or extinguish this court's jurisdiction. Section 1734 must be read in harmony with Section 91.5. Neither overrides the other, in our opinion. Both remain concurrently operative. Section 91.5, reinforced by Section 98.3, subsection C, confers on this Honorable Court an express and unqualified jurisdiction to give an opinion on any matter concerning the interpretation or application of this Constitution. The words any matter, as we've stated earlier, are unqualified. They necessarily include jurisdiction. Section 1734 must be read. Sorry, Your Lordships and Your Ladyship. This was confirmed in the Supreme Court decision where this court held that Cabinet's referral is unqualified, and the court is obliged to answer a lawfully referred question. It is our humble submission, sir, that question 5 has been lawfully referred by Cabinet. The settled jurisprudence of Fiji confirms that no ouster clause, as we have already indicated earlier in the Chandrika case, can shield the purported enforcement of a constitution from judicial scrutiny. Your Lordships and Your Ladyships, this Honorable Court, therefore, not only has jurisdiction, but carries the constitutional responsibility to determine question 5. In our view, to decline to answer would be to leave unresolved the very foundation of Fiji's constitutional order. In Kirk and Industrial Relations, the High Court of Australia said that no law of a state can remove the Supreme Court's supervisory jurisdiction in respect of jurisdictional error. The Chief Justice, His Lordship's French, held that no law of a state to remove the supervisory jurisdiction of a Supreme Court. If that is true for statutory Supreme Court in Australia, we submit that it is even more compelling here, where this court is expressly entrusted with the guardianship of Fiji's constitution. In the I wonder, my Lord, if I still have time.
Yep. Still got 14 minutes.
Bear with me, sir. I'll spend the last 10 minutes on the pathway that we seek. Your Lordships and Your Ladyship, the task before you is neither to draft a new constitution or to unsettle governance. It is to give an opinion, a clear statement of the law on the questions Cabinet has referred under Section 91.5. The proposition that we invite the court to opine on is minimalist in form, but decisive in effect, and it is based on the common law of Fiji from Chandrika Prasad to Ngarse. And in fact, this relies on the Ngarse decision. Number one, that this Honorable Court opined that the 1997 Constitution remains the de jure supreme law of Fiji. Number two, that the 2013 Constitution operates de facto as the framework of government until it is lawfully replaced. Number three, that only the people of Fiji, acting through the procedures in their Constitution, the 1997 Constitution, can lawfully replace it. Fiji's deliberate choice to follow those leading authorities that they had considered and accepted in Chandrika Prasad and affirmed in Ngarse to reject the success begets law, the guardrails are clear. Legality before power and consent before control. Your lordships and your ladyships, our propositions follows the guardrails Fiji's own courts have set. The state asks you to step outside those guardrails to replace Chandrika and Ngarse with a new doctrine. That time and political reality can convert an unlawful constitution into a lawful one. That would be a departure from the common law of Fiji, a path our courts have already considered and rejected. Our pathway, your lordship and your ladyship, restores legality without dismantling stability. Step one is the use of the necessity doctrine. The doctrine of necessity maintains the operation of the 2013 framework, so governance continue without chaos. This is what Ngarse recognized. Necessity may be used to preserve continuity, but only as a bridge back to legality. Number two, amendment machinery under necessity. Because the 1997 Constitution requires a bicameral parliament, and today's parliament is unicameral, necessity permits, in our view, and we invite the court to opine likewise, permit a temporary reconstitution of the Senate for the limited purpose of satisfying the amendment machinery in Chapter 15 of the 1997 Constitution. Step three, Parliament may pass legislation establishing a lawful process, consultation, drafting, and referendum on whether to amend the 1997 Constitution, ratify the 2013 Constitution, but it is for the people to decide. And number five, general election, that a general election is held under the constitutional framework chosen by the people. This is exactly what the Ngarse case taught. Necessity is not an end state, but a pathway back to constitutional order. Time does not matter. Whether 2 years, as in 2009, when the Court of Appeal decided the Ngarse case, or 12 years later. What matters is that the pathway exists and it has already been established in the common law of Fiji. The state's approach offers stability by freezing the status quo, but only at the cost of legality. It asks the court to treat time as the cure for illegality. But as Chandrika and Ngarse show, time cannot legalize what was unlawful in origin. Our pathway, your lordships and your ladyships, preserves both stability and legality restored. It keeps Fiji within the constitutional method its own courts have developed. And it is achievable in 2 to 3 years using the present parliament and a reconstituted Senate. What we are saying is simple. The people of Fiji must choose the constitution they live under. The court declares the law. Parliament manages the process, and the people of Fiji makes that decision. Your Lordship, Your Lordships and Your Ladyship, I do apologize, ma'am. In the Republic of Fiji, the Constitution belongs to the people of Fiji. This opinion reaffirms the truth. It tells the nation and the watching world that legality comes from the people's consent, not from the passage of time or the possession of power. Until the people of Fiji lawfully change it, their 1997 Constitution endures as the supreme law of Fiji. May it please the court.
Thank you.
That was what we would have.
Any questions? Right. So we move on to the next one. Any questions?
No question.
Right. Okay, we'll move on to the Fiji Labour Party. 45 minutes.
And Your Lordships, if I may, our preference, if at all the court allows, to proceed tomorrow morning, given that we believe that what transpired and the questions that were raised, we may be able to assist the court better with our answers refined. But we are ready to proceed, Your Lordships and my lady, if that is court's position.
You want to proceed tomorrow?
That is our preference, my lord, so that we can refine also. There's many questions raised by the court, and we can refine our answers to assist the court better.
What's tomorrow? 1, 2, tomorrow?
Yeah.
Unanimous. Tomorrow.
Much obliged, my lord.
Right. So, any questions before we knock off? Okay. In that case, Mr. Karuna, your request is granted, so we'll proceed at 9:30 tomorrow.
Much obliged, my lord.
And you will be the first one, and then after that, Unity, Fiji Human Rights Commission, and Fiji Law Society.
There's no more amendments tomorrow, though.
Right. Thank you for the work today. We'll see each other again tomorrow, 9:30. Thank you.